Good evening, because it's evening where I am. Not legal advice. Like, subscribe, watch, share. Send me questions, comments, anything along those lines. So in effect, it won't be all my videos, but this will be going an ongoing vlog of my arbitration, and I really see this as filing it on behalf or for the benefit of the MMTL community, which is an amazing community with many people who have been harmed by the nonsense that has gone on with MMTLP. So I'm happy to file and continue on with this arbitration, see what happens. Um, Depending on what happens elsewhere and how long those things take, I could always take different action with regard to the arbitration. So it started, and we will see where it goes and see what information I can ascertain. Um, I think I mentioned before my least favorite NHL owner, Doug from the Florida Panthers, said he hated one of my jokes. By the way, he's also a CEO of a hedge fund. Um, so, in honor of Dougie, I'm gonna continue on, and I'm gonna call these the honorary Dougie jokes. And tonight's joke: if two vegetarians get into an argument, is that still called a beef? Thanks again for little Bruce T out there for that great joke, and to Dougie, that is in your honor. So thank you, and good luck. So previously, I went through my submission, my arbitration submission. So filed arbitration against Fidelity through the FINRA system. Documents have been submitted, a submission form, a fee waiver request, and claim documents, and my proposed third amendment complaint. Um, I went through some of that, my submission, the portal, my request for a fee waiver. I indicated as to the fee waiver, so I must be psychic. Despite them asking for financial backup, I just submitted a declaration. I didn't really want to submit the financial backup information. So they're asking for W-2s and tax returns, and anybody else who seeks a fee waiver when they go through arbitration. If that happens, then they could decide if they want to submit those additional documents. So since my last part one, I did receive a communication from the, I guess, administer through the DR portal, and they, despite the fact my claim asked for a specific damage figure, they said please send them a specific damage figure, which I intend to do before the end of the weekend. They also said they asked for, surprisingly, additional documentation for the fee waiver. I'm going to reply with a further declaration, but no backup financial records, and I will apprise you where that goes. Just so you know also that if you file an arbitration, you can seek an expedited proceeding if you have health issues or you're 65 or older. So if you can prove you have health issues, you might be able to expedite the process even faster than it might go. And then the arbitration should be faster than a court process. That's the one benefit an arbitration will have over a court process. So prior video, I referenced that I had filed a claim, but did not mention what the claims themselves were. So in my claim, there's multiple sections. I'm going to kind of describe them. And it's drafted on bond paper. So it's white paper, not pleading paper. Pleading paper is numbered paper that you see like a complaint is filed. Something like this. This would be pleading paper where you see the numbers on the left side. And mine was filed on bond paper, something like this. So, just to give you an idea. You could do it on either. You could do it on pleading paper, you could do it on bond paper. But mine, I kind of divided up into multiple sections. I also said I attached as an exhibit my entire third amendment complaint, which sets forth my claims in an additional way. But the sections I used were, I had a brief introductory section, Then I had the specific legal claims, and I'll go over those briefly in a moment. A summary of the salient facts, and I didn't go over all the facts because if I did that, I could do 50 pages of that. But I kind of kept it short and sweet to the main facts and the main points that the shares haven't been delivered and all the nonsense. I would estimate that if someone was doing this and is not legal advice, KNOT, I would estimate that if someone was doing this by themselves, they could do it in 8 to 12 pages maybe, and adequately set out the claims, the facts, attach any exhibits to the extent they want. I think it could be done in that form, along with the submission agreement, which I talked about the last video, part 1. So as to the claims, I'm going to go briefly over the claims so you know what I asked. And just so you know, I started broadly, and some of these claims may not survive, and I understand that, but this is where we start, and we'll narrow it as it goes. And I'm sure this will give Fidelity Counsel some work to do over over the days when they get a chance. So the basic claims for relief were breach of contract. That's the arbitration agreement. That's the original agreement you sign up with your brokerage. So I claim they breached that agreement because they didn't give me the shares. I paid for them, didn't give me the shares, amongst other things. So that was one. Negligence, that they breached their standard of care. They did not operate to the standard of care. They didn't deliver shares, amongst other things. So for breach of contract, you're entitled to contractual damages. For negligence, you're entitled to tort damages. So it's what harm has been caused that could include emotional distress. And again, they operated beneath the standard of care. Then there's breach of fiduciary duty, that they owed a fiduciary duty to their customers, and they breached that by, amongst other things, failed to deliver the shares, diluting the interests of their customers, improper disclosures, aiding and abetting tax evasion, favoring some clients over other clients, naked shorting, etc., etc., etc. And those are repeated throughout. Usury, they charge me interest on nothing delivered. Breach of the implied covenant of good faith and fair dealing. And this is, remember, I'm in California. So in California, every contract has a promise of good faith and fair dealing that's implied in the agreement. And in this case, they obviously breached that by not giving me what they were supposed to give me and all the other facts that we talked about. There's an allegation, a claim for fraud related to all the other points we talked about, the misrepresentations. And this is interesting because recall that one of the FOIA responses refers to a December 5th, 2022 blue sheeting request. Those blue sheeting requests go out to the brokers, which means that when they respond, they know that information. And when they sell after they know that information and the shorting information, could be argued be fraud. So I have an intentional misrepresentation and then a negligent misrepresentation. So negligent misrepresentation means not that they did it intentionally, but they knew or should have known. So the information was there. Perhaps they didn't know, but they should have known. So that's a negligent misrepresentation. Conversion, I gave them money and they took it and didn't give me anything in return, and they're not returning it. Intentional infliction of emotional distress. That's a claim that whereby somebody acts with outrageous conduct and causes you emotional distress, you're entitled to relief. It really requires outrageous misconduct, at least in California. And I'm going to allege that for the various reasons, and one reason I just mentioned before, that this conduct was outrageous and unacceptable, and they're liable for emotional distress damages. And I'll get into that down the road. I think I have an interesting claim along those lines. And I know many people in the community who have been really harmed would have those kind of claims too. Then I have a claim for negligent infliction of emotional distress. Same thing, they engaged in outrageous conduct, but instead of intending it, they knew or should have known that it would cause harm. Then I have a claim for conspiracy, and it's conspiracy to commit all those prior claims: conspiracy to commit tax evasion, conspiracy to commit racketeering, conspiracy, etc. Conspiracy in and of itself is not a independent claim. It goes with a particular tort. Then I have a claim for racketeering, and we've gone through that. There are actions, multiple actions of naked shorting, etc. And I think even Mark indicated there was even a less onerous one version, but I don't think it applies in this particular case. An accounting, in other words, an additional claim for an accounting, which means they have to demonstrate what happened to my account, where the shares came from, and maybe we can get blue sheets or the like from Fidelity. And here's some additional claims: interference with prospective business advantage, and that means that maybe the broker took action which interfered in other businesses or investments I had. And I have one in mind that I won't talk about right now, but I have one in mind. So I'm alleging that the actions they took as to MMTLP may have interfered with other business relationships I have involving other things, not MMTLP. Again, I will describe that in greater detail when we get there. Negligent infliction of negligent interference with prospective business advantage. Same thing as the intentional, that they did conduct, but in this case, negligent interference means they knew or should have known, not that it was done intentionally. And the difference between an intentional and a negligent act is if something's done intentionally, you can also recover punitive damages. So in all the claims where I have mentioned an intentional claim, I'm also seeking punitive damages. Unfair business practices, that there are business practices in California violated California law, etc., including manipulative trading practices, naked shorting, etc. Manipulative and illegal trading practices, that's more of a federal claim, and that's self-evident what that is. Declaratory relief, I'm asking in this case, the arbiters to make a declaration of the rights of the parties as to multiple issues. And last but not least, I think this was claim number 19, I'm requesting a permanent injunction. I'm requesting that the arbiters issue a permanent injunction precluding Fidelity from engaging this conduct in California in the future at any time. So those are my 19 claims for relief. On top of that, what I just described, all that, at least factually, is described in my third amended complaint, which is attached. So that was my initial filing, and I will go into more detail about these claims. And if anybody has any specific questions about any of these claims, send out a comment, and I will try to answer it in a subsequent email or video. So this describes kind of what I filed to date, and today is Saturday, May 21st, 2023, and it's just the initial filing, and I will be filing additional documents, and as I file them, I will keep you apprised, and I hope this will push and add more pressure to the pressure cooker. Anyway, be well, and thanks to all you knotheads out there. Take care, be well.